show us what we don't want to see. All right, so the class is being recorded. So welcome again. My name is Jackton. I have said yesterday, and it's my pleasure to host us. Now, I want to start with criminal, and we are starting from, again, the relationship between criminal litigation and the criminal law that you guys did in campus. Now, you do remember in your campus, you did crimes, the law of crimes, and also as well as criminal law, which is the theory part of it. Okay. Now, in the Kenya School of Law, you are doing the criminal litigation. Now, criminal litigation is now simply the criminal law, but in court. How do you litigate criminal law in court, within the court system? That is all about the criminal litigation. Now, when you talk about the aspect of criminal litigation in court, you are looking at the procedural aspects of criminal law. From the point somebody has been arrested until the point somebody has been, the judgment has been delivered, whether the person is going to jail or is being sentenced to something, that in itself is the criminal procedure. So you need to understand that the first thing. Okay. Now, number two is that the setting in terms of criminal law assumes that you guys already understand criminal theory. Okay, there are certain things that will not be taught at the Kenya School of Law, but they will be said. Why are they being said? Because there's an assumption that you guys got time to go through them in your undergraduate studies. Okay, things like the theories in terms of the general procedures, general principles of criminal law. The second one is the question to do with evidence. The contents of the Evidence Act will always be set, but you will not be taught that in the Kenya School of Law. So again, it is upon you to go back in time and revisit your evidence law mastery so that you are not left behind when that question is set. Okay, now let's start from the introduction. If you look at your course outline, criminal is very wide. It's close to 20 something topics. Okay, close to 20 something topics. It's very, very wide. But we'll, of course, like I said yesterday, we'll do everything and then we'll do the past papers and see how the setting has been done. More so from June of 2021 all the way to the April of 2024, and also borrowing from the previous settings. That is from 2012 to 2019. So that is our structure. So I want us to start very quickly and lay some background and basis for you to understand. Now, criminal is very petty. It is so petty that you need to understand the details. This one you can't cram. There's no cramming. You have to understand the details. You have to understand the general perspective. You need to understand why we are here and why certain things are being done the way they're being done. Okay, so the first thing you need to understand are the general principles of criminal law. So the first thing you need to understand is the question of legality. But before you get to the question of legality, first understand who are the parties in a criminal litigation. Who are the parties? So the first person is the accused person. Okay, the accused person. So the accused person is the person that is a key figure when it comes to criminal litigation. That is the accused person. Are you together? So you need to understand that in the criminal litigation process, there's somebody called the accused person. That is the first one. The second person you need to understand is the prosecutor. Now, prosecution is very, very important. Prosecution is very, very important. And most of the time, people don't understand this entire idea of prosecution or who the prosecutor is and the functions of a prosecutor. You need to understand that. Now, when you look at Article 157, it creates the office of the DPP. It creates the office of the DPP. Now, the DPP is the head of prosecution. Okay, now that office of the DPP is given independent mandate to handle the question of prosecutions. It therefore means that the state prosecutorial powers will rest with the DPP. It is the DPP that will decide who to charge, when to charge, and how to charge them. I mean, on what basis. So that is the office of the Director of Public Prosecution. And therefore, at the back of your mind, also you need to understand that the DPP cannot be directed by any person. No person can direct the DPP on how to do their job because that office is independent. Even the court itself cannot direct the DPP on how to do its job. Are you together? And that we will discuss. So the next person that you need to understand is now the courts, the hierarchy of courts and the role of the courts in as far as the criminal procedure is concerned. What is the hierarchy of courts in as far as the criminal procedure is concerned? What happens at the magistrate courts? What happens at the High Court, the Court of Appeal, and the Supreme Court? What kind of jurisdictions are those courts having in as far as criminal is concerned? The next thing you need to understand is the role of the police. Okay, the role of the police. Now we've seen a shift in the role of the police because remember that before the 2010 Constitution, before the creation of the independent office of the Director of Public Prosecutions, we used to have police prosecutors. They drew the charge sheets, they presented parties for prosecutions, and that was that. And prosecution majorly was done from the office of the Attorney General, the State Council. Okay, so you need to understand that aspect. So what is the role of the police in as far as criminal law is concerned? Now that is going to form our second topic, which is the question of investigation. It's very, very important for you to understand. Investigation is our second topic, and that is the only thing that the police is supposed to do. The police will not do anything apart from investigation. Now, aside from the police, you also need to understand some of the criminal institutions. Now, these criminal institutions, they are relevant because when you get to the question of judicial review, we shall be discussing the role or how to handle these criminal institutions. And what are these institutions? The first one is the Office of the Inspector General of Police. That is the first one, the Office of the IG of Police. The second one is the Ministry of Defense, the Department of Defense. The next one is the DCI, the Directorate of Criminal Investigation. We have the EACC, that is the Ethics and Anti-Corruption Commission. We have the NCIC, that is the National Cohesion and Integration Commission. And we have other ministries or other bodies that are being given the mandate to take part in certain criminal investigation. We have the NIS. So those are criminal institutions. Why am I calling them criminal institutions? Because they have the mandate to make decisions that could bring a criminal charge on a person. So they are called criminal institutions. Now, these institutions, they are going to be very relevant once we start discussing the question of judicial review in criminal. But remember, judicial review is not criminal, neither is it civil. Judicial review is not a document, neither is it an institution. So when you discuss judicial review, that is how you will find how these institutions link within the criminal procedure. Are you together? So those are the key parties you need to understand. The key, the accused person. Who is the accused person? At what point is this person becoming the accused person? And what happens before this person becomes the accused person? We have the arrested person. We have the arrested person. Can you mute that thing? Zima Yogit. Who is that? Who is that? Let me come for you. Zima Yogit. Thank you very much. All right, so we have somebody called the suspect. Okay. The suspect mutates to become the arrested person. The arrested person becomes the accused person. The accused person becomes the convict if they're convicted. So don't just term that person as at every stage the name changes. So you need to understand at the back of your mind how that changes. So the first one, of course, we've said you're a suspect, you're arrested, you become an accused person. You only become an accused person after Article 41, 1, F, and G. Are you together? So that is the point you're going to become an an accused person. So we will come back to that. And of course, the role of the prosecution, you know that. Okay. Now, the next thing that you need to understand are now the basic principles of criminal law. The basic principles of criminal law. What is the first one? The first one is the principle of legality. This is something that you did in your high school, is it high school? In your campus, depending on which school you went to, you did criminal law, and one of the things you discussed, or the things you did, the question of legality. So what is legality? What is this thing you're calling, like, what is the principle of legality? So it is very simple. So legality dictates that there is no offense without the law. There is no punishment without the law. As simple as that. There is no offense without the law. There is no crime without the law. There is no punishment without the law. So how is that relevant? You're supposed to understand at the back of your mind that for somebody to be prosecuted, there must be an offense that they have committed. Now, you do understand when we start drafting charge sheets, you will be seeing that coming out clearly. When you draft the statement of the offense, the principle of legality must come out very clearly. How is that coming out very clearly? You must clearly say that this person committed this offense contrary to this section of the law. So without the law, there is no offense. Right, together, the same way, when you draft that section of your charge sheet or information, whichever it is, the principle of legality will come in where you prescribe the punishment, where you're saying there's no punishment without the law. So you must also tell us which part of the law prescribes the punishment for that specific offense. So that is the principle of legality. It is very simple. Nobody can be said to have committed an offense without the offense being prescribed in the law. And this you will see in a lot of stories. When you sit your exam, somebody can tell you this and this was happening, but at the back of your mind, you need to have it. You need to have it at the back of your mind that there's no crime, there's no punishment without the law. Guys, tuko sawa?
Yes, we are, Jackson.
Okay, that is fine. So the next thing that you also need to understand, another principle, is the question of burden of proof. The burden of proof. Now, there are two things. There's the legal burden and the evidentiary burden. Now, the legal burden of proof rests with the prosecution, and it is beyond reasonable doubt. The legal burden. So the burden to establish the commission of the offense or the guilt of the accused person is with the prosecution. It is a thread that runs through the entire criminal process, the entire criminal procedure. The question of the burden of proof, and the legal burden will always rest with the prosecution. And from that question of legal burden, or the burden of proof being on the prosecution, that is where we are getting the right to remain silent. The right to remain silent comes from the principle of the burden of proof. Because I don't have the burden to prove anything as an accused person, I have the right to remain silent. Okay? Now, if you do a deep dive from section 208, and you'll see how that burden comes into play. We look at section 208, that is the commencement of the trial process. The CPC prescribes the trial process. We have two things. We have the criminal procedure and we have the trial process. Now, the trial process begins immediately after the accused person has said they're not guilty, and it ends after they've been convicted or acquitted. But back to the question of burden. There are two things. There's one thing that comes from that aspect of burden, which is the right to remain silent. Now, you guys know that every accused person has the right to remain silent, but do you understand why they have the right to remain silent? Why do you think they have the right to remain silent? It is very simple. The right to remain silent comes from this aspect of burden. Now, because the accused person has nothing to prove or to show, they have the right to remain silent. However, the complainant, who is the person coming to the police station and recording a complaint that you stole their cow, that person has the right to speak. They have the burden to prove, and therefore they do not have the right to remain silent. And if they try to remain silent, then their case will be thrown out as per 208. And 208 says that after the accused person has said they are not guilty, then we shall proceed and hear the complainant and the complainant witness. It means the complainant must speak. if the complainant is not speaking, then there is no criminal case. Understand that? If the complainant is not saying anything, there is no case. However, when you go to section 211, after there's a case to answer, or after a case to answer has been established, then the accused person is given the option of remaining silent. And most of the time, you guys have called it, you plead the fifth. In other jurisdictions, they call it pleading the fifth. Now, it is only the accused person that can plead the fifth. The accused person can remain silent and say nothing. However, they can still call witnesses. But the complainant cannot enjoy that privilege of keeping quiet because we are in court because you complained. You cannot come to court and then say you want to keep quiet. Tell us why we are in court. And therefore, the legal burden will rest with the prosecution, which is composed of the prosecutor and the witness. And who is the first witness? That is the complainant. So the complainant is like the plaintiff. The complainant is like the plaintiff. Without the plaintiff, we throw out the case. Without the complainant, we throw out the criminal case. Through that, you'll get questions asking you about, hey, how do you, what are some of the instances where a criminal trial will be terminated before going to the full process? The first one is where the complainant is not available. If the complainant fails to attend court, then we are going to throw away the case because the legal burden rests with the prosecution. Tuko sawa? And then the next one is called the evidentiary burden. Now, the evidentiary burden always shifts. Okay? It is the burden to prove the validity of a piece of evidence. Now, that depends on the person that adduces the evidence. For instance, if the prosecution says that they have a video evidence, the burden rests on them to show that that video evidence is legit. Okay, if the accused person says that they have an alibi, then it is upon them to show that they have that alibi. Maybe produce pictures of them eating somewhere in Dubai or swimming somewhere in South Africa, that they were not available, they're not in the country. So you as the prosecutor, you as the accused person, you can't say that I was not in the country and then leave it at that. The evidentiary burden rests on you to adduce evidence to support your evidence for allegations as far as that evidence is concerned. That is the question of burden. And then of course we have the question of presumption of innocence. This is also a principle that runs through. So we have said the question of legality and how legality comes to play in terms of even drafting of charges. We have talked about the question of burden of proof, and we have said there are two types of burden, that the legal and the evidentiary burden, and we have said this is the mother of the right to remain silent. Okay, the right to remain silent on the accused person. Remember, we have somebody called a refractory witness. Okay, we have somebody called the refractory witness. Now let me connect those 2 points. The right to remain silent is only on the accused person. Only the accused person can remain silent. A witness cannot choose to remain silent. Even if whatever you're going to say is going to incriminate you, you as a witness, you cannot go to court and say that I have changed my mind. You can't change your mind. You will have to say whatever you want to say. And then once it has incriminated you, we will arrest you and you'll become an accused person, and then you can claim the right to remain silent. So that right is only available to the accused person. So always make sure, those of you that like speaking too much, when something happens, you're the witness. You're the scene of the crime all the time. When unajua kuelezea watu vile ilifanyika, siku moja takuramba sana. Remember that the moment you leave your house and you go and record a statement with the police and you are bonded as a witness, you can't change your mind and say, oh, this thing I'm going to say is going to incriminate me. You'll go to committee. And the law provides that if you don't answer the questions that are put to you as a witness, you're sent to jail for 8 days. Okay, so before you decide to become a witness, eyewitness, make sure you know the consequences, that the moment you become a witness, there is no going back. You have to say everything. And those everything that you're saying will somehow incriminate you. If they do, you'll have to go to jail. Okay? Unless you have a good lawyer. So that is the question of the right to remain silent, and that is where it is coming from. So have that background at the back of your mind. The next one is the question of presumption of innocence. Okay, now this presumption of innocence also gives birth to certain things. For instance, the presumption of innocence will also give rise to the question of burden of proof. Because I'm presumed innocent, I don't have the burden of proof. At the same time, presumption of innocence is one of the key principles when it comes to bail. So based on the fact that I have the right to be presumed innocent, I have the right to get bail. Okay, so that gives rise to the right to get bail. We'll talk about that later. And then, of course, generally need to understand what are the crimes. Which crimes do we have? It is very unfortunate that some of us don't even understand the crimes that we have. We don't know what crimes are there. You know, if somebody was to put a gun to your head and they tell you, hey, 20 crimes right now, mention 20 crimes right now, ama nakuua. Si hata wewe unaona tutakuja matanga yako. Even you know very well. Ni matanga tutakuja tukule. So make sure you know the crimes. Okay? Why do you need to know the crime? Because remember, the examiner will not call you my dear. Okay? The examiner will not be saying, my dear, now this question is about crimes and the following crimes are there. The examiner doesn't have time to dear you. It will not happen. Okay? The examiner will tell you, John was walking aimlessly in Rongai after drinking. John has been apprehended by the police. You are working for the police. Which charges will you bring or will you prefer against John? It is upon you to deduce the crimes. The examiner will not tell you that this will not put a notice board and say, hey, that question, these are the crimes. It will not happen. It is you to know. And therefore, it is important. Nobody will teach you crimes in the Kenya School of Law. Nobody will teach you that. They will not tell you that these are the crimes that we have. But it is upon you to bring out those, to know those, at least have the bare minimum. Murder, manslaughter, robbery, theft, the Sexual Offences Act, offences against a person, against the property, the traffic offences, offences against the document, treason, offences under the ICL. There are so many offences. Okay, so at least have some. Okay, have some so that you can save your life one day. You never know what happens. Life moves very crazy. So you might need to save your life by just mentioning 10 offenses. You can save your life. So please make sure you know those offenses. And then, of course, the question to do with the procedure, we are going to discuss that. So that is the overall background that we are dealing with. The overall background that we are dealing with. Now, the next thing that I also want to highlight very quickly is the question of legal framework, the legal framework around the criminal procedure. Now, this unit, like I've said before, is a very simple one. It's very simple. It is very simple, but you can also see dust. Okay, you can also see dust, real dust. If there's something that is very consistent, it's the dust. Okay, so please make sure that whatever I've said since I started speaking up to now is at the back of your mind. These are obviously, you need to have that background. If you have that background, trust me, there is nothing that is going to confuse you in terms of criminal law or the criminal litigation exams. Yes, Muriuki. Muriuki?
Yes, I just wanted you listed a number of institutions, criminal institutions that can bring charges. Inspector General of Police, DCI.
I didn't say that. Where?
Oh, sorry. The institutions that can make decisions that can result in a criminal case.
I didn't get your question.
I'm saying that you listed a couple of institutions that can make decisions which can result in a criminal case. and you mentioned Inspector General of Police and DCI. Could you just confirm the other examples?
No, thank you. Somebody type those things in the chat. There are things you don't need to even to re-mention again. I mean, nobody will ask you that question like you're asking it now. Nobody will ask you. But I just highlighted some of them. So don't emphasize on that. They're not really important, but you just need to understand this is, they could be anything. These institutions could be anything. It can be anyone. It depends on what the examiner is feeling like that day. They could wake up and say the county of Bungoma through the office of the county attorney. And that at that moment, the moment it is mentioned like that, that becomes an institution in itself. So remember that you cannot have an exhaustive list of that. You could even talk about the forest. The Kenya forest itself is an institution that could prefer some charges, could recommend charges to the DPP. Kenya Wildlife Service. They could recommend. There are a lot of things. Like, guys, there are millions and millions, hundreds of thousands of institutions. Okay, even when you leave your house, maybe to go to work, you will interact with institutions that will make some criminal-related decisions. Okay, the Highway Authority, Kenya, Kera, the traffic. So every institution can, because remember, everything is governed by a statute. Every statute has a penal provision. If it is traffic, if it is land, if it is water, if it is electricity, if it is even food, if it is motor vehicles, all those things are governed by a specific act. Each and every act has a penal provision. What is a penal provision? A penal provision is the provision creating an offense. For instance, you can say that it is an offense. Any person that maybe fails to adduce this is guilty of this. Even the KSL Act or the CLE Act. So even CLE itself can recommend the DPP to charge. So there are thousands and thousands and thousands of institutions, but the most rampant one, the most the serious culprits are the ones that I already mentioned. So somebody put them in the chat, but make sure you understand that everyone, anyone, the office of the president, the office of the governor, the office of the women representative, the office of the MCA, anyone can have that aspect of recommending charges. Even your church, when you steal from the coffers of the church, your pastor can recommend that you be sent to committee. So anybody can be there. All right, so the legal framework, quickly. So the first one is a penal code. The penal code is very important for you to have and understand. Now, the good thing is that when you walk into that exam, you will have your penal code. It is allowed that you need to have it in the exam, but having it is not an issue. The issue is knowing where what you're looking for is. You can have it, but you don't know how to use it, even where that offense is. Okay, so again, having the penal code will not help you in that exam. You'll take 50 years perusing the penal code, but you can't trace this crime. Where is it? So again, get time to go through the offenses in the penal code. Just peruse through. At the back of the penal code, at the very back of the penal code, there's a list of all offenses and where you will find them in the penal code. So that is obvious. The Criminal Procedure Code is the Bible of criminal litigation. The CPC, the Sexual Offences Act, guys. The Sexual Offences Act. Now remember that the Sexual Offences Act amended the penal code. There used to be sexual offenses in the penal code, and then the Sexual Offences Act was enacted, and those offenses under the penal code were transferred to the Sexual Offences Act. We don't have anything called the Rape Act. Some of you in the past have made reference to the Rape Act. We don't have anything like that in Kenya. We have the Sexual Offences Act. Okay, so we have offenses that are sexually related, and therefore they are found within the Sexual Offences Act. There are proposed amendments to the Sexual Offences Act. That is your first assignment of the day. Look at what are some of the proposed amendments to the Sexual Offences Act. Okay, we have the Constitution of Kenya 2010. Very, very important. Article 49, Article 50. Guys, you cannot avoid those two articles. You cannot pass, you will never pass, you'll never dream of passing unless you have read Article 49, Article 50. Okay, so if you're finding it hard for you to read those two articles, if you look at your reading timetable right now until the time exam is done, and you think that you will not be able to get some time to read Article 49 and Article 50, you need to defer the exams. You can't pass without reading those two articles. Because remember, somebody mute your microphone. Remember, guys, that the entire criminal procedure is based on Article 49 and Article 50. Okay? Article 49 is the rights of an arrested person. Article 50, the rights of an accused person. Are you together? Or the right to fair trial. Now, anytime within the criminal procedure, those two things must come to play. Either the person is arrested or the person is accused. So everything else, talk about, there's nothing in the CPC that is not from the Constitution. There's nothing in the CPC that is not from the Constitution. So instead of even reading the CPC, you first start by the Constitution and read Article 49, Article 50. And then you need also to understand Article 157. 157 is the one that creates the office of the DPP, and it gives the DPP the ultimate unlimited prosecutorial mandate. So 49, 50, and 157. Also the Bill of Rights. The Bill of Rights. You might find other things like the right to life, freedom of movement, that will form part of the question to do with bail, privacy, all those things. Article 47 is very important when we talk about judicial review, which is also very key in terms of criminal. So again, the Constitution, read the Constitution. And then, of course, we have the Evidence Act. You need to know the process in terms of adducing evidence based on the Evidence Act. What are some of the provisions in terms of even recording confessions and everything else like that? How do you record a confession? How do you take admissions? And all that, and all that, and all that. If you don't know that, then you might find it hard going through that. And then, of course, we have the question to do with the policies and the guidelines. We have the bail and bond policy. We have the sentencing policies. So all those also you need to understand, as they will help you to deal with the question to do with criminal. So that forms our background. And with that, I want to take two questions, and then we can go and discuss jurisdiction of courts. Jurisdiction of courts in criminal. Somebody, any question? Anything that is not making sense for you or to you? Now is the time. And I said yesterday, maybe for those who were not here yesterday, the best bet is to ask as many questions as you can. I don't eat people, I only eat food. Okay? And I say that I'm a friend to all. So take advantage of the friendship and ask as many questions. Even if it is a question that you think that is funny, ask it. Because the only way you're going to understand is by asking. I speak very fast, so sometimes you might not capture the things I've said, but please, please, please ask questions. Yes, Winfrida. Winfrida. Inango. Yusra.
Okay. So my question was, it's the DPP who has the right to commence proceedings, but to order for investigation, like to institute proceedings, and then let's say, for example, if it's an offense under let's say the KWS, and now they want to institute proceedings, can they institute their own proceedings, or they still have to go to the DPP and then so that the DPP is going to commence the proceedings on their behalf?
All right, let me explain that. So anybody can conduct investigation. Now, those institutions that I've mentioned, they just do investigation. They can only investigate. Okay, they can only investigate. But once they have investigated, we'll discuss investigation, then that file is taken to the DPP. What are they telling the DPP? Look, this is the file. We have investigated this person, and we think that he is guilty of this offense. And therefore, the DPP will look at the file and say, yes, from the file and the evidence you've collected, this person looks to be guilty. And therefore, they will have the person arrested and they will charge the person. Okay? So you as a person that is not the DPP, your work is to investigate and give the DPP the file. The DPP will not investigate. The DPP is not investigating anything. The DPP is not part of the investigation. The DPP prosecutes. Investigation is the work of the DCI, the ESCC. They will do the investigation. They will investigate. That is the Directorate of Criminal Investigation. They will investigate. Once they've investigated, they've arrested this person, they have to take the file to the DPP and then tell they cannot just wake up from nowhere and say, we have investigated, we are going to arrest this person and take him to court. No, they can't do that before they give the DPP the file. It is the DPP that will draw the charge sheet and say, fine, this person is being prosecuted. And of course, you saw that in the IG versus the DPP. Last year, there was a serious war between the Inspector General of Police and the Director of Public Prosecutions. And the court said in two occasions, that it is the DPP that has the right to institute or to decide whether somebody is being charged. So if you want to be a friend with anyone, be a friend of the DPP, because when you're a friend of the DPP, you will not be charged. Are we together?
Yes, we are. Thank you. That is very clear. Thank you, Jackton.
All right. Someone is saying what? Somebody is saying, please guide on the drafting that may be examined in criminal law. Anything can be drafted. There's no specific word. There's no specific list of what can be drafted. Winfrida, you can draft anything. They can even tell you to draft a love letter in an exam. Yes, you can. So start training yourself to draft a love letter. For those of you who never received love letters in high school, too sad. But what I'm saying is that you can draft anything. You can be told to draft anything, and anything means anything. So I cannot tell you that this is what you'll be expected to draft. No. But as we go through the individual topics, remember there are 20 topics. As we go through the individual topics, there are those topics that have certain things to be drafted. We will go through the drafting. For instance, when you go to the topic of charges, we will draft the charges. When you get to the topic of habeas corpus, we will draft the application. When you get to the topic of maybe judgment and whatever, we'll draft the judgment and the ruling. When you get to the topic of private prosecutions, we'll draft the application. So when you go to the question of judicial review, we'll draft the judicial review petition of the application. So what I'm saying is that each and every topic has something under it to be drafted. We will do that once we get there, but there's no specific list. I hope I've answered you. George, the grandson of Mau Mau. Are you the grandson of Mau Mau?
Hi, Jackton.
Hi.
Yes, I am one. So my question is Article 49C.
Who told you that? Wait. Who told you the grandson of Mau Mau?
I am from a lineage of a Mau Mau, so I am a grandson of Mau Mau. All right.
All right. Tell us.
My question is Article 49C, whereby every arrested person has a right to an advocate or someone with who they can communicate with. We visited with my friends Nairobi West Prison a month ago. And unfortunately, when I asked we had about 133 inmates. And when I asked whether any one of them had been exposed to an advocate or someone who could legally give them a bit of some knowledge. Unfortunately, out of the 133, none of them had that. So is it that it's just a plastic article they are put there to just make sure that our constitution is an activist constitution, or is it that the key stakeholders are not able to facilitate that, or they do not want, or is it that prisons are for the poor people or people who cannot be able to afford maybe an advocate? My question. Thank you.
All right. So remember, let me give you a quick answer. They cannot give you an advocate. When we say you have the right to an advocate, si eti tutakupea advocate ukikuwa arrested tunakupea hapo kwa gate ya prison. Hapana, that cannot work. If you have an advocate yourself as George, you will tell the police that I have a right to speak to my lawyer, and then they will tell you, call your lawyer and your lawyer will come. So if you don't have a lawyer, utakaa tu huko ndani. Okay? But when you are arrested while in the custody of the police, you have the right to see your lawyer or to see a lawyer. It is not that they must give you a lawyer. No, they can't give you a lawyer. Where are they going to get the lawyer? The only time you're supposed to be given a lawyer is under Article 52(2)(H), which has already been explained by the Supreme Court in Karisa Chengo versus Republic. The question of the right to representation, where substantial injustice would occur if you are supposed to be prosecuted without a lawyer. So when you go to court and you are supposed to be charged with a serious offense, then they have to give you a lawyer if you don't have one at the state's expense. That is an accused person. They will be given a lawyer. And the case that I've mentioned, that is Karisa Chengo versus Republic, is a Supreme Court case. The Supreme Court brought out the factors to be considered before we give you a lawyer. However, when you're an arrested person, we are not going to give you a lawyer as an arrested person, no. But you have a right to see a lawyer, to speak to a lawyer if you have one. Kama una wakili, tafuta sahi kabla ushikwe. Lakini ukishikwa, the police will not give you a lawyer. You can call your lawyer, and that right will come in place when now we are saying, because I have a lawyer, you cannot deny my lawyer from seeing me. That is how that article operates. Are we together, George?
Yes, well, much obliged.
All right, finally, Stephen.
I wanted to understand that some because
I lost
that
Stephen, I lost you. I lost you.
Oh,
What did you want to understand?
I wanted to understand. Are you getting me?
Yes, I am.
Are you getting me?
Yes,
I wanted
I'm
to understand how special are economic crimes. In economic crimes, somebody cannot just police station and report, be a complainant, and then the police just go and arrest a public officer for suspicion of being corrupt or suspicion for having committed economic crimes. That is, it is the EACC and DCI who has to investigate and has to take the file to the office of the DPP, and the DPP himself or herself is then was to approve for the charges to be filed against suspected person who has committed an economic crime. Different from these other crimes.
Remember, it is not a bar. It is not a bar. You, even yourself as Stephen, assuming that you have an employee, that you realize that this employee has been siphoning money from your business, or as involved himself or herself with some scandal, some corruption scandal, you can go to the police station and report the matter. Now, this matter will be investigated either by the EACC or by anyone. But at the end of the day, there must be an investigation. Before you go to the DPP, what the DPP is expecting is, hey, this is the report, this is the evidence. So normally, investigation of this public, public, or the commission of this economic crime, is normally done by the EACC. It is a body that is mandated to do that. But that doesn't stop you from, Stephen, from reporting that matter. So once you report it, then the police will now liaise with the EACC to do that investigation. But that also depends, because kwa ground vitu are very different, and it depends on how strong or how well you can lubricate the throats of the of the investigators. If you don't have anything, they will not be motivated to investigate your case. That is the sad reality. If you don't have anything, they'll not be motivated. But if you are someone, Steven or Jaco, if you're somebody, the moment you go to the police will inform the EACC that there's this investigation that is happening. Then immediately the EACC will take up the matter. They will investigate very quickly. They will recommend the DPP to charge, and the DPP will charge. So again, the will of the justice will moves very slowly, but also it depends on who is reporting. Okay. That is a sad reality, but you can go and report, yes, the police will do the investigation, and then they will proceed and make recommendations. They will proceed and make recommendations with the DPP, and then the DPP will decide whether they want to charge or not. Tuko sawa?
Okay.
All right, so the jurisdiction of courts, that is what I want us to discuss. The jurisdiction of courts. It is very important for you to understand jurisdiction of courts. It is extremely important for you to understand jurisdiction of courts. Okay, in criminal, it is very simple. Criminal, it is very, very simple. Jurisdiction of courts is very simple in criminal. So you need to understand what is the role of this of the magistrate courts, the High Court, the Court of Appeal, and the Supreme Court. So let's go. Now the first court, the last court is the magistrate court, which is the first court. Now the magistrate court will try all offenses. All offenses will be tried at the magistrate court, except, okay, murder, treason, offenses under the ICL, and the offenses of admiralty. What did I say? Murder, treason, any offense under the ICL, that is section 6, 7, no, article 6, article 7, article 8, article 9 of the Rome Statute. Okay, that is the crime of genocide, war crimes, crimes against humanity, and the crimes of aggression under section 9 of the Rome Statute. So those offenses are tried at the High Court. And then lastly is the offense of admiralty. That is the offenses that happen aboard a ship at sea. Okay, so we have the admiralty division of the High Court. We have the admiralty division of the High Court, which is situated in Mombasa. So all those, you'll not find admiralty offense in Nairobi or Kakamega or Busia. All of them will be Mombasa, because if anything, the sea is not anywhere in Kitale. The sea is in Mombasa. So all those offenses will be handled in Mombasa, because that is where the admiralty division of the High Court is, and that is both civil and criminal. So those are the offenses that are tried by the High Court, exclusively by the High Court. So anything that falls under that will be tried by the magistrate court. Now, there's a misconception in terms of capital offenses. Somebody thinks that all capital offenses are tried at the High Court. No, not all capital offenses are tried at the High Court. Okay, number one, the only capital offense that is tried at the High Court is murder and treason, and the ones that I've already mentioned. The rest, robbery with violence, manslaughter, robbery itself, all those are tried at the magistrate court. So don't confuse that. Don't confuse the fact that it is a capital offense, therefore it is in the High Court. No, all of them are tried at the magistrate court, except for murder, treason, offenses under the ICL, that is section, article 6 and up to 9 of the Rome Statute, and then offenses at sea, the admiralty offenses. So all those offenses are handled by the High Court. The rest are handled by the magistrate court. If you look at the CPC, the second should be the second or the fifth schedule of the CPC. It provides for all the offenses and which court will try them. All the offenses and which court will try them. So that is the magistrate court. Now the magistrate court, again, does not have any jurisdiction when it comes to the human rights violation. The magistrate court do not have those rights. Now, in theory, somehow, some very excited, some judicially excited judges will normally mention that they have some jurisdiction to entertain questions with torture and anything. They don't have that. Okay, so when it comes to human rights violation, it is specifically the High Court. Are you together? So that is the Magistrate Court. Any question? Any question? We are fine. We are good. Somebody say yes.
Yes, we are good.
Yes, we
Okay.
are, Jackson.
Next
Just raise
is
the hand.
come again. Somebody say something. I'm not getting what you're saying. Tianga Jennifer. Jennifer Tianga. Tianga. Is it Tianga or Tianga? Jennifer, your hand is up. We can't hear you. You're not speaking. You're muted.
Hi.
Mm.
You can hear me?
Yes, I can.
Yeah, it's Tianga. It's Tianga. So
Okay.
it's just a slight clarification that I need. You said offenses of admiralty, this ones that will occur at sea. So my question would be, so if someone was to commit murder aboard a vessel, and then you take them to, does this mean then that they wouldn't be charged at the normal High Court? If you charge them at the normal High Court, the High Court does not have the jurisdiction for this.
No, it is a High Court. It is a High Court. Murder is a High Court. So it doesn't matter which division is a High Court. But remember, what are the admiralty offenses? Murder is just murder. Murder is not anything to do with admiralty. Admiralty offenses, things like hijacking, when you hijack a ship. So we have those admiralty offenses. For instance, a ship is at the high seas and it is hijacked by the pirates. You understand piracy, you understand the aspect of piracy. So when you hijack a ship or you steal goods that are on transit from a ship or any piracy related offenses, those are admiralty offenses. They are handled at the High Court. Are you together?
Together, thank you.
So aside from that, then everything else is tried by the relevant court. But also remember why we sometimes try these offenses at the High Court. Why? Because most of the time, this ship will be at the high seas. Okay? And when a ship is at the high sea, no specific country is claiming jurisdiction on that. So if it is an offense that is committed on a ship at the high seas, and this ship is registered or is flying the Kenyan flag, though there are very few ships, I don't think there's any ship that is registered in Kenya. There's none actually, unless somebody wants to confirm. There's no ship that is registered in Kenya. There's no ship in Kenya. I mean, we don't have a Kenyan ship like that. All ships are flying different flags of different countries, and it has things to do with regulations, taxation, and everything else. They could be Kenyan ships, but they don't fly the Kenyan flag because the flag that the ship is flying will determine the question of taxation, regulations, the workforce, and everything else. So Kenya, we still don't have that capability to sustain ships in terms of our legal framework. And therefore, most of the ships, even those that dock at the port of Mombasa, they're flying a different flag. Okay? And most ships in Africa and in the world are flying which flag? Somebody? Which flag? That is your assignment.
Liberia.
So, Liberia. Yes. So most ships in the world, and not just in, of course, in Africa and in the world, they're flying the Liberian flag because Liberian is a tax haven. It is very, very accommodative to the ship owners and then the maritime law. So that is why. So most ships you'll see at the port of Mombasa, they'll be flying the Liberian flag, or sometimes Ethiopian, but rarely you find the Liberian flag because Liberia has made it very easy for ship owners to register their ships in Liberia. All right, sawa. So any offense that is committed aboard a vessel, that offense is handled by the High Court for the fact that it is admiralty related, and also the fact that if it is an offense that is committed at the high seas, then the High Court, the Magistrate Court cannot claim jurisdiction. So it is the High Court that will de facto get that jurisdiction and prosecute those matters. But of course, we have admiralty offenses, like I've mentioned, some piracy, hijacking, all those things, trying to steal goods that are on board and everything else. So those things are handled by the High Court. And because it is sea-related, it is normally the Admiralty Division of the High Court that is in Mombasa. So you'll not come and file it in Kitale. All right, sawa. So, all right, sawa. So that is the Magistrate Court. So Magistrate Court will try all offenses except the ones that I've already mentioned. Let us go to the High Court. The High Court is very specific. It's very large and wide, but you need to understand that. The first one, when it comes to the jurisdiction of the High Court, is the original jurisdiction. But before we get there, remember that the High Court is the superior court. The High Court is the superior court. There is only one superior court, and I've explained this yesterday, I've explained this before, time over time. There's only one superior court. Why am I mentioning that? You will be told that James was convicted by the superior court, or James appealed to the superior court, or the decision of the superior court, or the judge of the superior court. Now, there's only one superior court in that context, which is the High Court. Why is the High Court deemed to be the superior court? Because it is only the High Court that has unlimited jurisdiction in all criminal and civil matters. There's no any other court anywhere in the country that has that unlimited jurisdiction. The Court of Appeal has only appellate jurisdiction. The Supreme Court has no original jurisdiction in criminal matters. I hope you understand that. The Supreme Court has no original jurisdictions in criminal matters. All criminal matters, they will end up at the Court of Appeal. The Court of Appeal is the court of last resort in all criminal matters. Are you together? So that is why the High Court is the superior court. It is the one that has unlimited jurisdiction. So go to the High Court. So the original jurisdiction in murder, treason. So in terms of murder and treason, in terms of treason, you need to understand two things. There's the actual offense under Section 40, which is treason, and we have other treason-related offenses. For instance, if you admit an oath, that is not treason. That is a treason, offenses related to treason. Now, offenses related to treason are tried at the Magistrate Court. Okay? Treason itself is tried at the High Court. So in 2017, when Kajwang, you remember the scandal, the Kajwang, Miguna, Raila, and everyone who was involved in the admission of or the swearing in of Raila Odinga as the people's president. I don't know what that is, but it was sworn in as that, the people's president, and they arrested him. He ran away. So they arrested Miguna and TJ and were charged with offenses related to treason. And because they fear charging Raila with treason, they didn't charge Raila. So Raila himself would be guilty of treason. Of course, the courts have pronounced themselves on that matter very clearly, that amounted to treason. It will amount to treason. It is treasonous. Okay. So, but aside from that, the things like Kajwang, Miguna, they're offenses related to treason. Are you together? So if you look at Section 59 of the Penal Code, it is not treason, but is an offense related to treason. For instance, when you're present, what we're charging Kajwang with is being present, okay, during the administration of an oath. Okay, so that is, I want you to understand that not everything that has the word treason in it is treason. Treason is just treason. Okay, treason is just treason. But we have offenses related to treason. All those are tried at the magistrate court, but the mother of them all, which is treason, is tried at the high court. And then murder. So again, the basic point is understand the difference between murder and manslaughter. Murder and manslaughter. Manslaughter is tried at the magistrate court. The magistrate will have the power or the jurisdiction to entertain the manslaughter charge sheet. However, murder is only handled at the high court. So the fact that somebody has died doesn't mean that is the high court. You need to deduce whether it is murder or it is manslaughter. You know the difference. So that is the high court. So the first one is original jurisdiction. And I've said murder, treason, offenses under the ICL, genocide, the offense of genocide, war crimes, crimes against humanity, and also, of course, the question to do with the crimes of aggression. That is the crimes against peace, when you suspend peace. So that is the crimes of aggression. So those offenses are tried at the High Court, as well as the offenses related to admiralty, offenses at sea, aboard a ship, including piracy and hijacking, and all those. Those offenses are tried at the High Court. Okay, so that being said and done, that is the original jurisdiction. And the other aspect of original jurisdiction is the court has original jurisdiction to entertain applications to do with, number one, the habeas corpus application. Habeas corpus is only handled at the High Court. Any habeas corpus is only handled, any habeas corpus application is handled at the High Court. Habeas corpus, original jurisdiction. The other one is jurisdiction to handle applications related to violation of human rights and the applicability and interpretation of the Constitution. So if within the criminal trial, something comes up within the trial, the criminal trial, the High Court will have the jurisdiction to entertain that question. Are we together? So the question could be, like I've already mentioned, anything to do with the applicability and constitutionality of a given section, like, the Muratetu case, the question of the illegality of section 204 of the Penal Code, the legality or the constitutionality of it. Okay, that was handled in that case. That was handled in that case. So the High Court has the original jurisdiction to entertain it first. Okay, and then of course, after that, we have the appellate jurisdiction. The High Court will handle all the appellate jurisdiction, all the appeals that are coming from the subordinate courts. Which are the criminal subordinate courts? First, we have the Anti-Corruption Court, we have the Magistrate Courts, and we have the Court Martial. Okay, we have the Court Martial, as well as the Children's Court. So I want you to understand one thing. All these are called subordinate courts. Now, not all subordinate courts are magistrate courts. So which ones are the subordinate courts? Okay, number one, the magistrate courts. These are subordinate courts. The court martial is a subordinate court. The other one is the children's court. Remember that we have a specific children's court. It is a children's court. Okay, that is a subordinate court. So any appeal, of course, we also have the Anti-Corruption Court that handles questions to do with corruptions and related. So also you need to understand those are subordinate courts. So any appeal that is coming from these courts will go straight to the High Court. They'll go straight to the High Court. We used to have district courts, but that was scrapped. So district courts, these are courts that were headed by the chiefs, the district magistrates. These were Africans that did not go to school, and therefore they could only handle the district court. So when you're appealing from the district court, you have to go to the chief magistrate. You appeal to the chief magistrate, and then from the chief magistrate to the High Court. But that was dealt with and therefore we no longer have the district courts. All right, so that is the question of appeal. So the High Court handles the first appeals from all subordinate courts. First appeals. The High Court does not handle anything second appeal. It is just first appeals from the subordinate court. The other one is what we are calling the supervisory jurisdiction of the High Court. Supervisory jurisdiction of the High Court. How is the High Court supposed to supervise? Okay, the first one is judicial review, supervisory jurisdiction of the court. The second one is through revision. The third one is through retrial. Are we together? So, supervisory jurisdiction of the court, that is the High Court, is manifested in three ways. Judicial review. Judicial review. The next one is revision. The third one is retrial. Are you together? So in other way, judicial review is an original jurisdiction. Yes, it is an original jurisdiction, but at the same time, it is supervisory jurisdiction. The same as the retrial is an original jurisdiction, but also it is supervisory. Now let's start with the JR. Now you do remember I said yesterday that judicial review is not a document, it is a remedy. Now this remedy is granted either in civil or in criminal. It is just a remedy. Compensation, damages, those are remedies. So judicial review is one of them. And this comes from Article 233F. That the High Court shall have the power to grant, after entertaining applications that are filed under Article 22, they will have the power to give the remedies listed under 2.3. Okay, and 233F provides for orders of judicial review. Now the High Court has that specific mandate, and it is only the High Court that can handle it. So in criminal, the High Court has the power to judicially review the administrative decisions that have been made by the criminal institutions. So the person that was asking this question, this is how it now plugs in. So if a criminal institution makes a decision that you think as an accused person or as an arrested person or as a suspect is violating your Article 47, then you shall run to the High Court and you shall sue that specific criminal institution through judicial review, and you shall be seeking the orders of judicial review, specifically the orders of certiorari, the quashing orders. Are you together? So let me give you an example of those decisions. Okay, number one is, the first one is the DPP. So the first culprit that you can change the decision through judicial review is the DPP. The IG of police, the DCI, the EACC, the NCIC, the NIS, the Ministry of Defense. Okay, anyone. So if they make a decision that you think is violating your Article 47, guys, remember, it must violate Article 47. There's no judicial review without Article 47. So it must violate Article 47. How do you know that something is violating Article 47? If it is against the rules of natural justice. What are the rules of natural justice? Number one, when you make a decision, the person affected by that decision must be given a notice, a reasonable, sufficient notice. Number two, they must be heard. They must be given time to be heard. Number three, they must be given time to represent themselves. Representation. The other one, they must be given reasons for that decision. The fifth one is that they must be given the right to appeal. This is everything that is provided for under Article 47. So the administrative right or the right to a fair administrative action is very simple. Like I've said, the first one is that the person that is being affected by the decision made by this body, they must get the notice. Okay? They must be given time to be heard and to represent themselves. They must be given reasons of those decisions, and they must be given an opportunity to appeal it. Okay, so the reason itself must be fair and reasonable. So you give a fair reason, a fair decision, and it must be reasonable. And then aside from that, the person affected by it must be given notice. So, those are rules of natural justice. So if you think that the decision of the DPP, the DCI, the Inspector General of Police, the NIC, the NIS, okay, is violating the rules of natural justice, then you shall run to the High Court through a judicial review petition or application, and you shall be seeking, among others, the 3 orders of judicial review to quash the decision of those bodies. Example, the DPP has heard that you are going to vie maybe for Makadara constituency, and they now want to charge you. They're bringing charges because they think they're going to stop your political ambition. There's nothing. The charges are trumped up charges. There's no basis for the charges. They're just charging you because they want to affect you. They want to affect your political ambition. So you will go to court and have the court quash the decision to charge. So how do you challenge the decision to charge? Judicial review, quashing the decision to charge, and thereby quashing the charge sheet. How do you challenge a defective charge sheet? Through an application to quash the charge sheet, which is different from judicial review. I don't know whether somebody is getting confused, really. If you're confused, put up your hand. Very well. You guys are not confused. All right, Sawa. So you're getting what I'm saying? Somebody is having their hand up. Huku Lindsay, what is your question and what is your bone of contention? And then you can have Rachel Omondi. Dhuku, is it Tuku or Dhuku?
It's Tuku, but you lost me at the an application to quash a charge sheet. And how it's different from a JR. What application would you make in such an instance then?
All right, there are 2 things. Okay. So let's say the DPP is charging Huku Lindsay. The DPP has said you have committed some fraud. Okay. In your mind, you've not committed any fraud. In fact, they're just trying to trample those charges up so that you don't vie as the next women rep for Nairobi. Okay. They have not done any investigation. They don't have any evidence to show that you committed the fraud. They're just charging you to waste time and to buy you from vying. So in that instance, you are challenging their decision to charge you. You are saying, why are you charging me? That is one instance. The second instance is you've been charged with fraud, but the charge sheet has a problem. It is defective. It is not properly drafted. It does not spell your name correctly. It is saying Thuku, but it's saying a different person. It is not saying the exact offense you committed. It is misquoting the section. It is duplicitous. It is not even signed. It is not even dated. So there's a problem with the charge sheet. But you're not challenging them charging you. You're just telling them you're charging me through the wrong way. So in the first instance, you are challenging the decision to bring the charge sheet. Okay? The second instance, you are not challenging the decision, but you're challenging the charge sheet itself. So if your main problem is the charge sheet that is defective, this charge sheet is defective because it is duplicitous, it is not signed, not dated, it does not have the statement of offense or the particulars of offense, you quash the charge sheet. You strike the charge sheet. It's like when somebody files a plaint, okay, and the plaint is not properly drafted, you will apply for the striking out of the pleading, that the plaint be struck out. The same way, if the charge sheet is not properly drafted, you will proceed and apply for the striking out of the charge sheet. You're saying, if you're going to come at me, you better come right. Okay, so you pray that the charge sheet be struck out. Are we together? So that is an application which is done through a notice of motion and a supporting affidavit, and you're just saying strike out the charge sheet based on the following ground. The other one is that you are challenging the entire thing. You're first challenging the decision. So if you successfully challenge the decision, then it doesn't matter whether the charge sheet was properly drafted. You will also strike out the charge sheet. Because if you challenge the decision successfully, then there should be no charge sheet. And therefore, if there was already a charge sheet, you strike out the charge sheet as well. So I hope you get the difference. When you challenge the decision, you're going to court and saying, these people should not charge me. Why are they charging me? They have not even given me the reasons. There is no nothing, no investigation, no nothing. 2019 question 1. 2021 June question 6. 2021 November question 6. All those questions are almost the same thing. They talk about judicial review. So in terms of judicial review, we are talking about Article 47, and we are saying that the decision, which is administrative, remember this institution, they are administrative institutions. Now, the decisions that they make are administrative decisions. So if you think that this decision is affecting my right, rules of natural justice, then you are going to deal with it through the normal judicial review process and strike it out. When you strike out that decision, the consequence is that even the charge sheet will be thrown out. However, if you are not challenging the decision, you're saying, fine, you can charge me. For instance, you know very well that you committed this crime, but yes, the charge sheet is not properly drafted. You will use that as a technicality to throw away the charge sheet. So when you're throwing away the charge sheet, you just make an application for striking out the charge sheet or quashing the charge sheet. So quashing doesn't mean judicial review. Judicial review orders can come with a quashing order, but it doesn't mean that every time you seek quashing, it is judicial review. No, quashing is just a normal English word that means to strike. Are we together? To strike out. So that is what I was saying. Are we on the same page?
Yeah, thanks.
Okay, so that is judicial review. We will have an entire discussion about judicial review. Do not worry. The next one is revision. Revision is very important. This is a right that is given to the High Court under Section 362 of the CPC, as well as the Constitution, as well as 364 of the CPC. So 362, as read together with 364, as read together with 354, 356, and 357 of the CPC. Right together. These are the provisions that are bringing to light the question of revision. Okay, so it is a special power that is given to the High Court to revise decisions that are being given by the magistrates. Okay, it is very simple. Now remember the history of revision as a power. Now revision was provided or was brought in the picture during the colonial times. Remember that the High Court judges used to be white men, the Brits. They used to be in the they used to sit in the High Court, and then the magistrates used to be the Black Africans. Okay, now to make sure that they were supervising the powers of the Black magistrates, who they thought were not even capable of understanding the law, they introduced the CPC. I mean, they introduced a revision in the CPC. Now that power allowed the judges at any time, without even being prompted, at any time, to call for a file that is before the magistrate. It doesn't matter whether the magistrate is still handling the file. The judge can call for the file and correct an order that the magistrate has made at any time. So it was that is how it evolved. It was a way of supervising the African magistrates, and then it became part of us. And now it is still power of the High Court. Even the question to do with the trial of murder and treason in the High Court, it was a colonial thing. They thought that certain offenses could not be handled by African magistrates, and therefore they were given to the High Court specifically. At the same time, even the mode of approaching the High Court is different from the mode of approaching the magistrate. If you're going to the magistrate, you just need a simple charge sheet. But if you're going to the High Court, it is called an information. It's the same thing, but the structure is different. So that is how those things came to be part of our legal system. So that is the power revision. So revision is a supervisory power. It is the High Court supervising the subordinate courts, the magistrate court. So the High Court can call for the file at any time. You don't have to apply for it. The High Court can do that. So either you can apply, you can prompt the High Court, or the judge will be sitting at home watching television, and then you will see in the news that the magistrate in this court has done the following things. The judge will go to his office tomorrow and write to the magistrate, tell him to bring the file, and then he will change the orders in that file. Are you together? So that is that. At the same time, there's the positive side of revision, whereby you as a magistrate, if you're a newly admitted or a newly appointed magistrate and you make a mistake in the file, you make the wrong order in a file, you don't have to panic. You simply take the file to a judge and the judge will correct it. You can't correct it yourself. You have to take it to a judge. Just call a judge or approach the judge in that station, and the judge will correct it through revision. So that power is given to the High Court. So that is the power of the High Court to revise. So we'll discuss again revision at length. And lastly is retrial. Now retrial is a special power of the High Court that is guaranteed under Article 50(2)(6). Article 56, not Article 56. It is Article 56. It is not Article 5(6). It is Article 5(6). It is not Article 56, it is Article 5(6). It means Article 50, sub-Article 6. Okay? That is the power of retrial. Okay? And it is very specific that at any time, once somebody has appealed to the highest court, or they have been locked out of appealing because of time, and a new evidence has come up, they're allowed to apply to the High Court and have the High Court order a retrial based on the new evidence that has come up. So you know what review is under Order 45 of the CPR, that is the Civil Procedure Rules. You know what review is. You can review an order if there's a new and compelling evidence that has come in place. Now, in criminal, review is now called a retrial. But we are saying that if there's a new and compelling evidence, there are two options for you. You can appeal. If you have a new and compelling evidence in criminal, after being convicted, there's a new and compelling evidence. For instance, you saw the case in, let's even use the Joey Rungu case. Though I don't think there's any new evidence that will come up. Let's use Joey's case. Joey has been convicted to death, sentenced to death, convicted of murder and sentenced to death, to suffer death. Okay? Now, if new evidence comes up right now that, hey, Monica Kimani has been seen somewhere at the beach enjoying her life, or in Southern Sudan enjoying her life there, yet Joey has been sentenced to death for killing her, then that is a new evidence. So the moment that new evidence reaches Joey Rungu, then Joey Rungu will have two options. The first option is to appeal. But remember, you can only appeal within a specified period of time. Okay? So if Joey Irungu cannot appeal because time has gone, or because he had appealed until the Court of Appeal and his appeal had been thrown out, then the only option that is available for him is to apply for a retrial. And that means you can't apply for a retrial if you can still appeal. So what are the two things that will make you not to appeal? The first one, you already appealed. You already appeal until the court of last resort. And which is the court of last resort? The Court of Appeal. Umeappeal mpaka Court of Appeal, na your appeal was not successful. Or you've not appealed, but time of appealing is gone. The appeal time is gone. Okay? You're supposed to appeal within 14 days from the magistrate court to the High Court. You've not done that. You're supposed to appeal within 44 days, around 44 days, 14 days for notice of appeal, and then you have another 60 days, actually 60 days to file a memorandum of appeal in the Court of Appeal. You've not done that. So if you are out of time, you can't appeal. So in that instance, and you have a new evidence that is a new and compelling evidence, you shall apply for retrial. Now, what is a retrial? The High Court is ordering that reopen the file. You judge or you magistrate that handle this matter, reopen the file and retry it afresh based on this new evidence. Okay? So even if Monica Kimani is seen alive, Joey Irungu will not be free just like that. In fact, unless Joey Irungu has taken an active step to apply for a trial or to appeal, he will be in prison for the rest of his life, or he will be even be murdered. Is it not? It's not mad. It's not murder. That's not murder. That is execution. He'll be executed, killed, even though Monica Kimani is alive. The court is blind. Remember, the court is blind. You have to move the court. So it is upon Joey, and Joey cannot walk out of committee and say, "Hata nyinyi meona news, huo mama ako alive, mimi naenda nyumbani." You can't do that. You must be moved, but you must move the court. So even if the same judge that convicted Joey Irungu was watching, the same judge that convicted Joey Irungu was watching the news, and she sees in the news that Monica Kimani is alive, she can do nothing about it. She can't do nothing about it. Joey Irungu must come to court and move the court. If he doesn't move the court, ataishi committee. So based on that principle, you have to move the court through a retrial. So the matter is retried again. Okay, it is retried again based on the new evidence that has come up. That is how we handle that. That is a retrial. So we will have an entire topic on retrials, revisions, judicial review, and appeals. That is the jurisdiction of the High Court. And then we go to the Court of Appeal. The Court of Appeal only handles appeals. Either the first appeal, that is appeal coming from the High Court to the Court of Appeal. And then somebody says, "Zema hiyo kitu bana. Huyu nani? Ben Ogombe. Zema." Okay, so the Court of Appeal only handles appeals, either the first appeal or second appeals. What is a second appeal? A second appeal is the appeal that came from the magistrate court to the High Court, and then from the High Court to the Court of Appeal. And then first appeal is appeals on murder and treason or offenses that are tried in the High Court, from the High Court to the Court of Appeal. That is the Court of Appeal. Now, the Supreme Court has no jurisdiction in criminal matters. The Supreme Court has no jurisdiction whatsoever in criminal matters. Uko sawa? Any question? Swali?
Let me ask this.
Wait. Put up your hand. If you have a question, put up your hand. Every person having a question, mikono juu. And then we can pick all the questions. Yes, Alan Odur.
Yeah. When you say the Supreme Court has no criminal jurisdiction, does it mean that an aggrieved person who on second appeal went to the Court of Appeal cannot move to the Supreme Court in case he has been convicted in a criminal offense?
Okay, that is the first question. Rachel Omondi, what is your question?
Can you hear me?
Mm-hmm.
Yes, hello. Just to take you back a little bit, when you said that murder is only tried at the High Court, I just wanted to know your opinion on the decision. I think it was a 2020 decision, a constitutional petition in Kisumu, where it was ruled that murder cases should start at first instance from the magistrate's court.
Yes, that is Justice Ocheng. That is Justice Ocheng in Kisumu in 2020 of December. the AG. Remember that it must be operationalized by the amendment of the CPC, but that has not been done. So until the CPC is amended, we are still stuck with that. So the AG was given time, I think 18 months to operationalize that. He has not. So again, we are still stuck with murder at the High Court, even though the courts have said you can start it from the Magistrate Court, but that will need an amendment to the CPC. But before that amendment is operationalized, nothing can be done. Now, let me handle the question and explain why the Supreme Court has no jurisdiction. Okay, has no jurisdiction in criminal matters. Now, the Supreme Court is a constitutional court. It is not a factual court. All criminal appeals, like the question of I am guilty, I'm not guilty, that question ends at the Court of Appeal. Whether you're guilty or not will end at the Court of Appeal. That is the first thing to understand, that all criminal appeals will end at the Court of Appeal. The question of guilt or not will end there. However, you can only go to the Supreme Court if you are challenging the legality of a given provision of the law, okay, or an interpretation of a given section of the law, or the constitutionality of a given provision of the law. Let's take, for instance, Francis Kariuki Muratetu. Okay, you know the case of Francis Kariuki Muratetu in the early 2000s. This guy, alongside other 6 people, they drill down this guy in Kitengela. They kill him, and then all of them are arrested. They're prosecuted, and they're sentenced to death in the High Court. They appeal to the Court of Appeal, and their death sentence is upheld. And then they go to the Supreme Court. Now, remember that when Muratetu went to the Supreme Court, Muratetu was not challenging whether he's guilty or not. Remember the unfolding of Muratetu. This guy, at some point, the wife got pregnant while they're in the cells. It's a very convoluted story. So one of the questions that came up, one of the stories that came up is, when you pass a death sentence on an expecting woman, do you kill the mother and the child? Do you wait until the child is born and then kill the mother? So those kind of questions. Now that prompted Muratetu to go to the Supreme Court, not to challenge, not to tell the court that, hey, the Supreme Court, I'm not guilty. No. Muratetu went there to challenge the constitutionality of Section 204 of the Penal Code, which is the mandatory death penalty. Okay, and the court agreed that the mandatory death penalty is unconstitutional, but the death penalty is constitutional. Are you together? So the matter was referred back to be retried to the High Court. It was referred back for another consideration by the High Court. Are you together? But the Supreme Court cannot say you are guilty or not guilty. No. The Supreme Court doesn't say that. They don't have that jurisdiction. They don't entertain that. They can only say that Section 204 is unconstitutional or it is constitutional. Leave alone that. Let's go to Karisa Chengo versus Republic. Karisa Chengo went to the Supreme Court to challenge and to seek an interpretation of Article 52H, which says that every person has the right to be given an advocate. Now, that is the question that took Karisa Chengo to the Supreme Court. Now, Karisa Chengo, after challenging his guilt at the Court of Appeal, which is the end of it, he cannot now go to the Supreme Court and say, I'm claiming that I'm not guilty. No, you can only go there to seek an interpretation of a given section. Okay, interpretation of a given section, the constitutionality. So in that case, again, the Supreme Court pronounced itself by saying, yes, Article 52H is very clear in terms of when somebody should be given an advocate, and the Supreme Court gave under paragraph 7.7, it should be 7.7. Yeah, gave the parameters to be followed before somebody has been given an advocate in a criminal trial. Let us look at even the question to do with Joseph Lindrex Waswa, again a Supreme Court case. Now, Joseph Lindrex went to the Supreme Court not to challenge his guilt or his conviction, but to ask the court, the Supreme Court, to define and to explain itself on the participation of an advocate watching brief. Okay? Who is an advocate watching brief, and what extent can that advocate participate in the criminal trial? Now, who is this advocate watching brief? The advocate watching brief is the advocate of the victim. Normally, the complainant is not supposed to hire the advocate. Why? Because the prosecutor is like the advocate of the complainant. But if the family is rich, the family can hire their own lawyer to walk alongside the prosecutor and to assist the prosecutor or to watch. So that person, we are calling him an advocate watching brief. Why is he watching? Because remember, 157 says that it is only the prosecutor that can prosecute actively. Therefore, any person that has been hired by the complainant is an audience, an advocate watching brief. However, in Lindrex Waswa, the Supreme Court explained under paragraph 77, paragraph 77 of that case, yes, it is paragraph 77, says very well that there is limits on what that person can do. They can question witnesses, they can file submissions, they can do this and that, but with a given limitation. So essentially what I'm saying is this: if you look at all criminal matters that have gone to the Supreme Court, we are not challenging the conviction. We are not saying whether you're guilty or not. We are simply challenging or seeking the interpretation of the Supreme Court on one thing: the legality of something, or the constitutionality of something, or the applicability of a section of the law. Remember again under Article 163, what matters are supposed to go to the High Court, so the Supreme Court. These are matters that have been certified by the Court of Appeal, number one, on a question that is of great public importance, and a question that is challenging or seeking the interpretation or the applicability of the Constitution, nothing else. So that is when we go to the Supreme Court. The Supreme Court, like I've said, cannot say that you are innocent. Even in the Muratetu case, the Supreme Court agreed with Muratetu and told Muratetu, yes, 204 is unconstitutional in as far as it is mandatory. But sisi kama Supreme Court, we don't have the power to give a sentence. So go back to the High Court with this judgment and have the High Court relook it again. And that was Muratetu 1. You know what happened after Muratetu 1, and then the Supreme Court had to sit again in Muratetu 2 and give clarifications in as far as the Muratetu decision is concerned. So I hope I've answered you, and I hope everybody now understands why the Supreme Court has no criminal jurisdiction. Okay? But the Supreme Court can prefer charges. Okay? If you misbehave before the Supreme Court, you can be charged with contempt and punished, okay, by the Supreme Court itself. So don't play with the Supreme Court. Also remember, the Supreme Court is an institution. So even though it is a court, it can sometimes act as an institution, and therefore decisions of the Supreme Court as an institution can be challenged through judicial review in the High Court. Because how? So we are saying if the Supreme Court is acting as an institution, and that decision is affecting your Article 47, you can go to the High Court, and the High Court will nullify the decision of the Supreme Court as an institution. I'll give you an instance. The Ahmed Nasir issue. You know, the Supreme Court barred Ahmed Nasir from appearing before it. That was not a decision of the Supreme Court as a court. It was a decision of the Supreme Court as an institution. It was not a judicial decision. Now, because it is not a judicial decision, it is a decision that is administrative. And therefore, you, like, of course, you know that Ahmed Nasir went to the High Court, and the High Court is entertaining that application and will give its decision whether they are going to quash the decision of the institution. Again, at the same time, you know very well that the Supreme Court can do things. For instance, the Supreme Court can order water, the Supreme Court can order lunch, can enter into contracts. The Supreme Court make decisions that are not court-related because it is an institution. The Supreme Court has employees. So it doesn't mean that now the Supreme Court is above the law. No. We are simply saying we can still subject the Supreme Court to the jurisdiction of the High Court because the High Court is still superior to the Supreme Court. It is still the superior court. The Supreme Court is not a superior court. So understand the Supreme Court in the judicial context and in the administrative context. For instance, the Supreme Court has cars. Okay? So if you're knocked down by a car that belongs to the Supreme Court, you sue the Supreme Court in the magistrate court. Okay? If you have a contract with the Supreme Court that is above 20 million and they've breached the contract, you sue the Supreme Court in the High Court. I hope you understand that. So over and above, you understand why I'm saying the Supreme Court does not have any criminal jurisdiction, but the jurisdiction is limited to constitutionality and applicability of the Constitution. Alan Oduor, tuko sawa?
Tuko sawa.
All right. So that is that. So that is the entire jurisdiction of the courts, and I hope you understand that clearly. Any question? Any comment? Addition, subtractions, feelings, reservations? Okay. Now, yes, Alan.
Yeah, just which provisions did you cite when you are talking about revision?
I said the first one is 362. That is the one that establishes the power of the High Court to call for records. It is read together with section 364 of the CPC. Now, why did I make reference to 354, 356, 357, and 358? Remember that the powers of the court, that is the High Court, during revision are the same powers of the High Court during appeal. So the orders the court can make during it sitting as an appellate court is the same powers that court can make when they're sitting on a revision application. And therefore, remember that 350 from 350 of the CPC all the way to section 358 talks about the power of the High Court as an appellate court, the power of the High Court as an appellate court. And therefore, 364.1 says that during revision applications, the High Court shall have all the powers that have been given to it as an appellate court under section 354, 5, 6, 7, and 8. They can do anything, just like an appeal. It means anything that is appealable can be revised. Anything that is appealable can be revised, and the power of the High Court will have the same thing. So 350, of course, 165, the Constitution, 362, 364, and then all the powers that are provided for under 354, all the way to 358, which is now the powers of the appellate court. Tuko sawa? Alan?
Yes.
Okay, that is that. Now, I want us to talk about something else. Now, we are done with the question of jurisdiction. Now, let us go to, let us discuss the last limb of our discussion tonight, which is the question to do with arrest. Arrest. Okay, arrest. So what is arrest? I know everybody here, most people have been arrested. And if you're not arrested, if you haven't been arrested, at least if you're a Christian, you know that Jesus Christ was arrested on your behalf. I'm not sure whether Muhammad was arrested also as the Muslims. Was Bare Ibrahim, was Muhammad ever arrested like Jesus as well? Ibrahim?
No, he wasn't arrested, but he was prosecuted.
Was prosecuted without arrest?
Persecuted, I mean.
Oh, okay. So, yes. So, Christians can relate. If you're not arrested, you know Jesus Christ was arrested on your behalf. So everybody has been arrested. But even aside from that, you've seen people getting arrested. You've watched movies, people getting arrested. You've seen people getting arrested. So arrest, very important, very easy, simple to the point. Okay. Now, under arrest, I want you to understand a few things, just a few things. Guys, life is already hard. Okay. Like I've said, life is hard. The last thing you want to do is to complicate your life again by making criminal law very hard. Make it very simple. We'll talk about introduction, legal framework, jurisdiction. Obvious things, basic. Now, it's getting even easier. Okay. and easier by discussing the question of people getting arrested. Now, you've seen people getting arrested all the time, so don't complicate arrest, obviously. So the first thing you need to understand in terms of arrest is what it is. What is arrest? What is arrest? Arrest, what is it? Okay. The other thing you need to understand is who can arrest. Who? Okay. What it is, who can arrest, how to arrest, what happens after somebody has been arrested. Okay. After that, you need to understand reasonable or no, proportional force, the concept of proportional force. Okay. You need to understand the warrants as well as the search warrants. Those are not actively set, but we'll discuss it. Then also, like I've said, the Bible of this one is Article 49, the rights of an arrested person. Okay, so that is all you need to understand about the question of being arrested. Section 129 of the Section 129 of the CPC 100 36, 36A, Article 49, Section 118, all those sections, Section 25, all those sections are relevant when it comes to the question of arrest. So let's start with what it is. The apprehension of a person's body. Okay, so when a body is confined, the confinement of a person's body, that is somebody's being arrested. Okay, so that is as simple as that. When your body has been confined, you've been arrested. Okay, you can either be arrested actually or just by communication. When you're told, Barry Ibrahim, you are under arrest, immediately you've been arrested. The fact that you've been told you are under arrest, even though they have not touched you, they don't have to touch you. The police doesn't have to touch you. But of course, the Kenyan police will not resist the urge to touch you when they're arresting you. They don't have to touch you. The law makes it very clear. They don't have to touch you. They can just communicate that, Barry Ibrahim, you are under arrest. Please come with us. But they don't do that. They don't resist the urge to touch you when they arrest you. So they have to touch you. They have to mishandle you and throw you. I don't know, whatever it is. So remember that even though you've not been touched, the fact that they have told you that you are under arrest, you're already under arrest. Okay, that is what arrest is. The question is, who can arrest? That is obvious questions. A lot of people can arrest. Everybody can arrest. So the first one is the police. The police have the power to arrest. Officers of the EACC, officers of parliament, captains of ships, captains of aircraft. We have the chief, the private persons, magistrates, judges. They can effect an arrest. All those people can effect an arrest. So and you'll find a question where somebody has been arrested by private citizens, and they're coming to you and they're telling you that their right has been violated because they were arrested by public citizens. Now you'll need to do an opinion to advise them whether a private citizen can arrest and who else can arrest if not the police. It is a very simple thing, guys. Dealing with these things, very, very simple. So don't complicate it. Very, very simple. So those are the people that can effect an arrest. Okay. Now, in terms of how, we have something called a warrant of arrest, which of course you must have seen, you must have heard, you must have seen Form 5. Form 5 is appeal. Form 5 is appeal. So we have warrants of arrest. If you work in the judiciary, you might have seen them. Warrants to issue. If the magistrate says that, for the judge says that warrants to issue, it means you're going to be arrested. That a warrant is going to be issued. Okay. So in terms of warrants of arrest, you need to understand that there are offenses that can be arrestable using a warrant and without a warrant. The most rampant one are when you can be arrested without a warrant. So anyone wants to tell us? Everybody put up your hand. When do you think somebody can be arrested without a warrant? Section 129 of the Section 29 of the CPC. Section 29 of the CPC. When do you think somebody can be arrested without a warrant? At least kila mtu weka mikono juu. Put up your hand, guys. Na pia wenye wameshikwa, kuna wenye wasikiangi vizuri kabla wajashikwa, so kila wiki lazima washikwe. They have to conflict with the law every day. So kama wajashikwa 1 week, wanasikia kama ni wagonjwa sana. So put up your hand if you're that kind of a person as well. Yeah. All right, so can see we have, let's start with Nancy Oduor.
Yes, Council, good evening.
Good evening.
So I believe one can be arrested without a warrant when they commit a cognizable offense in front of a police officer.
Commission of a cognizable offense. Yes.
For
Thank
example,
you very much. Yes.
Yeah.
Proceed.
I'm saying, for example, if you start beating your wife in front of a police officer.
Yes. That is yeah, that is a serious one. That is a serious offense. In fact, that is domestic violence. Domestic violence is a serious offense. It's very serious, by the way. Domestic violence or gender-based violence is a very serious offense. When we talk about the question of mitigation and aggravation under sentences, you will realize how serious domestic violence or gender-based violence is. Okay, and also you remember that the defense of a battered woman. Okay, you know the defense of a battered woman. Justice Aburili, the lady that killed the husband, and was sentenced to 1 day in prison. So committing a gender-based violence is a serious one, very, very serious. Okay, so if your client has committed gender-based violence, start preparing them or start having them making friends at committee, because that is where they're headed to. Domestic violence and gender-based violence, very, very serious. So you can do anything in this world, but don't commit gender-based violence, don't commit a sexual offense. If your client commits those ones, look for friends in committee, because that is where your client is headed. So anyway, if you commit a cognizable offense, just a commission of a cognizable offense is a ground to be arrested without a warrant. At the same time, commission of an offense in front of a police officer. They don't have to go look for a warrant when they can actually see what you've done. Nyambane.
A person can be arrested without a warrant if he is suspected to have escaped or attempted to escape from lawful custody.
Yes, if you've been arrested and you have escaped, you are escaping unlawful custody, you will be arrested without a warrant. Kamiri John.
Evening, sir.
Yes, evening.
Yeah, I want to believe that you will definitely be arrested without a warrant when you have a contempt of court.
What do you mean you want to believe? Let's start there.
Meaning, you're in the courtroom, and then you decide to misbehave inside the courtroom. You'll definitely be arrested, and no warrant will be wanted. As well as when you breach when you commit the breach of peace, whether within the court corridors or outside the court corridors.
All right, yes. That is still commission of offense in front of a person that can effect an arrest. Yes, you'll be arrested instantly. Yes, Tracy?
When you're found in possession of stolen goods.
Yes. When you're handling stolen property, you're found in possession of stolen things. Some things were stolen, you steal something, and if it is a jacket, you're still putting it on. If it's a phone, you're using it. You know, your place is in committee. Okay, so that is that. That is another reason why you'll be arrested without a warrant. Yes, Kinango. Yusra.
If a person is believed to be a deserter of the armed forces.
If you desert the armed forces, you'll be arrested without a warrant. When you join the armed forces, you don't just leave the way you want. If you desert, there are consequences. Yes. Another one, Nancy. Okay. Okay, so guys, there's so many of them. There's so many of them under Section 109. When I found loitering, loitering is an offense. You don't just walk anyhow. So if you're loitering on the streets at the wee hours of the night, of course you will be arrested. If you're found to be in possession of tools that are believed to have been used for housebreaking, of course you'll be arrested without a warrant. Breach of peace, again, you'll be arrested without a warrant. Okay, now that again takes us to the next thing, which is now when you can be arrested with a warrant. Of course, when you commit an uncognizable offense, these are petty offenses. If you commit these petty offenses, of course, there will be need for a warrant. And then the other thing you need to understand is what is a warrant of arrest? What is a warrant of arrest, and what are some of the things that go into the warrant of arrest? So in terms of warrants of arrest, it is the court that issues a warrant. It is the court that issues a warrant of arrest. So you have to apply for the warrant. You have to apply for the warrant, and that is under Section 100. You have to apply for the warrant of arrest. And that warrant of arrest is issued by the court. It is only the court that can issue the warrant of arrest, and then you will have to be arrested. Okay. Now, what are some of the contents of the warrant? What are some of the contents of the warrants of arrest? What are the contents of the warrant? The first one, the warrant of arrest must define the person to be arrested. The warrant of arrest must define the person to be arrested. That is the first one. The second one, the warrant of arrest must specify the reasons for their arrest. Okay? The warrant of arrest must specify the reasons of their arrest. Why? Who do you want to arrest? Why do you want to arrest them? The third one is that the warrant must specifically define the person to carry out the arrest. We together? The warrant must specify the person to conduct or to carry out the arrest. So it is addressed to a specific person. Okay. The fourth one is that the arrest must also define the issuer, the person that is issuing the warrant. This warrant is issued by whom? Okay. The next thing is the warrant must specify what is supposed to happen after the person is arrested. Once you arrest the person, what is supposed to happen? So the warrant will say they must be produced before this court at this time or at this place. So that is another content of the warrant. It must specify what happens after they've been arrested. Once you arrest them, what? Why? What happens? So who is to be arrested? Why they're being arrested? Who is arresting them? What happens after they've been arrested? The next thing, it must be signed and must be dated. A warrant of arrest must be signed and must be dated. Must be signed and must be dated. Now, from that information that I've given you, you can prepare your own warrant of arrest. It doesn't take any other form. It can take any form. Okay, a warrant can have any form. So you can, so long as it has everything that I've already said, that is a warrant. And then, of course, you know the rules. It must be endorsed if it is supposed to be executed in, in a different jurisdiction. It must be endorsed and re-executed by that other jurisdiction of the court in that jurisdiction. Are we together? And then, of course, you know that a warrant of arrest can only be used once. You can't use the warrant twice. Once the person has been arrested, the warrant will expire, and you can't use it again. Even if you arrest them today and they escape tomorrow, you can't use the same warrant to arrest them again. That warrant expires once it has been executed. So that is a warrant of arrest. You can prepare your own warrant just so long as it has the things that I've already mentioned. And I've said for you to get a warrant, you must apply to court. The application is a notice of motion application and a supporting affidavit. Why do you want this person to be arrested, and what have they done? So your reasons. But also remember that courts do issue warrants of arrest if the person has disobeyed summons. You don't have to apply for that one. So if the person has disobeyed summons, you're supposed to appear before the court, you have refused to appear, or you've jumped bail, the warrant of arrest will be issued against you without any application. So that is a warrant of arrest. And then the question again that also we have to understand is the question to do with reasonable or proportional force. Now, guys, at any time you are effecting an arrest, you must always use reasonable force, or proportional force. Don't kill while trying to arrest someone. Now, you know that the question of arrest borders two offenses, manslaughter and assault, grievous assault. So if you beat someone while arresting them, you will be charged with assault. But if they die, you will be charged with manslaughter. Hope you're getting what I'm saying. So always make sure that you're using proportional force to effect the arrest. If somebody is trying to escape, don't shoot their head, shoot their leg. Okay? You don't have to beat someone when you're effecting an arrest. And of course, Kenyan police, they don't understand that. That point does not exist for them. Okay, so that is just that. So you have to use reasonable force, and there are a lot of decisions in this. Of course, the locus classicus is Muhero versus Uganda. In Muhero versus Uganda, someone was suspecting that someone was stealing their beans, and therefore they went to arrest this person who was stealing their beans. They cut their legs, and this person bleeds to death. This person was convicted of manslaughter for trying to arrest this person by cutting their legs. Very, very funny. Okay, so if you bleed to death as a result of the mode of arresting that has been used, then the person that assaulted you will be charged with manslaughter or murder, depending on the available evidence. So that is Muhero versus Uganda. All the time, make sure you're using reasonable force. Don't use excess force or excessive force when trying to effect an arrest. And then, of course, the other thing that you need to understand is, of course, before I move to something else, is what we're calling the searches, the search warrant. It is not a big deal like that, but you need to also understand search warrants. That first is a very simple thing. If you look at section 118 of the CPC, it clearly says that you can apply for a search warrant ex parte. So if you want to search a house or a vessel, you have to go to court, apply to court, notice of motion, supporting affidavit, and get a search warrant, okay, to search the place. You can't search somebody's place without a warrant. And that warrant can be issued at any time, including Sunday, and it can be executed at any time, including Sunday. But a warrant can only be, a search warrant can only be executed during the day, that is sunrise to sunset. You cannot execute it after sunset without the leave of court. So it's only the court that can allow you to search somebody's place at night. But again, you guys, sometimes on the ground, things are different. The police will just come to your place and they search your house and they do all those manner of things. We've seen that a lot of times. But remember that a search warrant, the first thing is that you have to apply to court and you have to swear an affidavit giving the reasons why you want to search that place, and is normally ex parte. Ex parte in this context that you don't involve the respondent when you make the application. It must be handled urgently. Why? Because it will, if you involve the respondent, it will defeat the purpose of the search warrant. They will, of course, have everything hidden before you can search. Are you together? That is search warrant. So application to court before you can search. Okay, so there's nothing crazy about search warrants. Warrants of arrest, I've already mentioned that. Who can arrest, what arrest is, what happens after that, and then the transition into court. So I want us to discuss that in 2 minutes. Yes, Nancy?
Yes, Counsel. I believe that when you are applying for a search warrant, you have to indicate whatever you are going to search for. So if you take any other evidence you find there that you did not include in the search, can it be admissible in court?
Yes and no. The fruits of a poisonous tree. You remember that principle? The fruits of a poisonous tree. You go to somebody's house because you are searching for guns, but you don't get the guns, or you get the guns and weed, for instance. There's nothing like weed. It's not weed. It's marijuana. Bang. I don't know why you guys call it weed. Anyway, you find bang in that person's house. It depends. The circumstances. The Kenyan courts, in other jurisdiction, you can't use that evidence anywhere. But the fruit of a poisonous tree, that principle does not apply in Kenya. Okay, that is illegally obtained evidence. They call it illegally obtained evidence. Now, there are instances where the courts have admitted illegally obtained evidence. If it is relevant to the case, the court will use it, even though it was not subject of the search. For instance, you went there looking for guns, but you found other explosives. You could use that as evidence, and the court will admit it without having to get into litigation in terms of that evidence. But also remember that there are instances where the courts have refused to admit evidence that is obtained illegally. Okay, remember Article 50 again says that the obtaining of the evidence must be done in a way that corresponds with the Constitution, and that therefore means that at some point illegally obtained evidence should not be used. But if you look at the case law, it says that we don't have a specific position in terms of illegally obtained evidence. So some courts will admit it, but of course courts have said that it is only admissible if it is relevant to the case and if it will not violate the rights of the accused person. So it is a very funny balance. Some admit it, some don't admit it. There are exceptions to the rule, and yeah. Are you together?
Okay, thank you, Counsel.
All right, thank you. Kamiri John, lastly.
Yeah, the most important aspect in the search warrant is how justifiable is it? Is it that you cannot be able to litigate without that particular aspect, which is definitely violating the right to privacy?
Yeah, remember, like I've said, remember that you have to make an application and swear an affidavit. Now, that affidavit will indicate what you want to search and why you want to search it. And the relevance, of course, you have to indicate why is it important for you to search it and how relevant is it to this case or to your investigation and everything else. So again, nobody will just give you a search warrant to go and search somebody's house for no reason. Remember, Justice Lord Denning says that a man's house is his castle. So unless the reasons, serious reasons, there are no reasons why the court would allow you to search somebody's house unless there are serious reasons. And those reasons can only be provided through an affidavit. So you have to swear an affidavit, do an application, have an affidavit, and clearly indicate why you want to search the house. Okay. Now, the last bit of that is the question to do with remand by court. Remand by court. So Article 49(1)(f) and G and 36A of the CPC, remand by court. Now, I will give just an introduction to that and then we will discuss it later. But before we discuss it later, take note of the following sections that you must understand even as you prepare. The first section, I call them the A's, okay, because there are amendments to the CPC. The first one is 36A, 42A, 123A, 123A, take note of 137A, and then take note of 348A. Okay, So 36A is remand by court, 42A is the right to disclosure, 123A is amendment to bail, 137A is plea agreements, 348A is appeals. So those are their amendments. So the first A that we're going to deal with is section 36A. Now 36A defines now how do you translate or how do you balance the right, of an arrested person and the duty of the police in terms of investigations. Okay, remember that investigation, which is our next topic, arrest is part of investigation. You arrest because of investigation or as part of investigation. Okay, now you had instances where the police will arrest you, they will produce you before the court, and they will say, no, we don't want to charge you, we want to keep you waiting. Okay, we don't want to charge and we want to keep you waiting as we do our investigation. So they're saying, no, we don't want to release you now. We are still proceeding with our investigation. Please, the court, give us more time. Okay. Now, what is the history of that? Now, if you look at Article 49(1)(f) and G, remember that Article 49 is the one that talks about the rights of an arrested person. Okay, the rights of an arrested person. Now, 46(1)(f) and G say that every arrested person on the first appearance before the court will have 3 rights. When a person has been arrested, the first thing is that they must be produced before the court within 24 hours, unless the 24 hours falls on a weekend, okay, falls on a weekend or a day that the court is not sitting, or a public holiday. Now, aside from that, when the person is first brought before the court, when the person is arraigned before the court for the first time, there are 3 rights that this person will have. The first one, under F and G, is the right to be charged. You have the right to be charged. You've been arrested, you've been brought before the court, you should be charged. If you're not being charged, you need to be released. If they're not going to charge you, why are they holding you? They need to release you. And then thirdly, if they don't release you and they don't charge you, they need to give you reasons. They need to explain to you why they are holding you without charging you or releasing you. And that gives us, you remember the Friday arrest? The police will arrest you on Friday, they will keep you over the weekend, and then on Monday, they will either release you or they will go to court and say, hey, we are still doing our investigation. We want to arrest you and keep you in custody as we do our investigation. Now, there's been different jurisprudence in that matter, a lot of them consistent, and how you're supposed to deal with that. Okay, I will give an example. So we have Michael Rotich versus Republic. Michael Rotich versus Republic. Michael Rotich versus Republic. Now, who is Michael Rotich? Michael Rotich was an athlete. Okay, Michael Rotich was an athlete. This nigga or this guy went to Rio. Okay, they went to Rio, the Olympics. So after going to Rio, he was accused of doping. And he was deported back to Kenya. So when this guy was deported back to Kenya, the moment he landed at JKIA, the moment he landed, touchdown, he was arrested for embarrassing the whole nation in Brazil. Okay, so he came back from Rio because of doping charges. He landed and he was arrested. Now, once he was arrested, he was presented to Milimani before the magistrate, and the police said, we don't want to charge him yet. We are still doing our investigation. The magistrate ordered that they be, Michael Rotich to be in custody as the police is doing their investigation. Now, Michael Rotich applied for revision in the High Court. And at that time, Justice Luka Kimaru was sitting in the High Court. So he applied for revision of the orders of the magistrate, having him held in custody pending investigation. Okay? Now, Luka Kimaru said, or the court said, that you cannot hold someone past 24 hours pending your investigation without a holding charge. Okay? So the court said, no, you can't hold this person without a holding charge. That is the first example. Okay? The second example is engineer Oscar Sudi. Oscar Kipchumba Suri versus Republic. Remember the time in 2022, when Suri, alongside other people, were accused of insulting the First Lady, then the Kenya's First Lady, that is Mama Ngina Kenyatta. Remember that case where Sudi was accused of insulting Mama Ngina? And then he was arrested. He was availed before the magistrate in Nakuru, and the police said that was through the NCIC, the National Cohesion Integration Commission, Kaparo, and they said, no, we don't want to charge Sudi first. We want to hold him in custody as we do our investigation. The magistrate agreed and allowed the prosecution to hold Sudi for 30 days as they do their investigation. Sudi applied for revision in the High Court. Of course, Professor Ngugi was sitting in the High Court in Nakuru, and Ngugi, making reference to Justice Luka Kimaru's case in Michael Rotich versus the Republic, said the same thing, that you cannot hold a person pending your investigation without a holding charge. So what is the finding in all these cases? That for you to hold a person, you must have a holding charge. Holding charge is what is the most probable charge that you'll bring against this person? What is the charge? What are you investigating? You cannot have a blanket word investigation and then you're arrested. So the question was, go and do your investigation and then come and arrest. Do not limit the person's right to liberty without reasonable ground. So that is what the court said. You cannot hold somebody as you do the investigation unless you have a holding charge. Now, as a result of that provision in the Constitution, or as a result of that case, the CPC was amended under Section 36. The CPC was amended under Section 36, which gave us 36A. Okay. Now, under 36A, the Parliament or the law provided for a specific procedure that the police are supposed to follow when they are holding somebody beyond 24 hours without a charge. Okay. They have to bring the person before the court. They have to make an application through a notice of motion supporting affidavit. They have to give the reasons why they're holding the person. And one of the things that the court said in terms of establishing a holding charge is, what is the suspicion? What evidence have you collected? What evidence are you intending to collect? What is the scope of the investigation that you've conducted? And what is the reason why you want to hold this person as you do your investigation? That was the factors the court said, and you have to include them in your supporting affidavit. So that is the withholding charge. So in the next class, we shall be starting from remand by court, section 36A. We'll go to the question to do with investigation, the process of investigation and the role of the police, and how you can help the police, making reference to June 2021 question 1 and making reference to November 2021 question 1 as well, because those two questions are the same thing. They are testing on the question of investigation and the role of the police and your role as a person helping the police, more so in the preparation of file. So in the next class, we complete arrest, clarify a few things, look at the cases. We'll look at the ID parade and the process of investigation, and then we will start on complaints and charges next week. Complaints and charges, drafting of charge sheets, drafting of information, joint of parties, joint of counts, duplicity, and finally, the application to amend or to quash a charge sheet. So again, moving bit by bit, we're doing well. Guys, that is it for today. I open the floor for any form of questions that you have. It doesn't have to be what we have discussed today. If you have a question that you have on anything that is criminal, even from your current affairs, whatever is going on in that country, you can always ask. Okay, it is exactly 8:45 p.m., 15 minutes past the hour. So questions? Questions? No question. All right. If there's no question, I'm going to stop the recording now. Guys, are we together? Somebody confirm. Are we guys together? Are we on the same page? Are we moving together? I need to know that.
Very much together.
All right.
We appreciate
Yes,
Thank you
we
very
are
much.
together.
Yes, we're
All
together.
right.
You.
All right, then.